You're listening to the Valley Current.
So with that backgrounder, I sent something that I think kind of fits into the educational series, and it might be worthy of doing some newsletter on, which is this guy came up with this idea of having a T-shirt that used the three words Trump too small, which he wanted to claim trademark rights over. So I don't know if people saw it, but this case generated a fair amount of litigation because the trademark office refused to register the mark, even though it was being used in commerce and so on. And the guy says it's political speech because the trademark office said our policy is we don't register a trademark with someone's name, their personal name, unless you get the consent. And obviously, Donald Trump was not going to consent to someone owning a trademark that has his name in it. So let's just stop there and ask the generic question. Is that trademark regulation or that statutory provision in the trademark law? I sent the petition for certiorari, and I'll go through the procedural history in a minute, but is that policy of requiring the consent of a person's name, is that somehow as a matter of law wrong? Like, just think of that in the abstract.
I didn't even think you could trade. I didn't think it had anything to do with that. I didn't think you could go trademarking someone's name when you're actually referring to their name.
That's you can with their consent, clearly, if he gave consent.
Right. I guess that's what they consider the same as that person doing
Or
it.
they consider it that the person is granting permission or a license or something else, or it's a related party, or
Right.
there can be multiple Trumps too, right? In theory, there could be somebody else's name. Like this guy could have gotten someone whose last name.
Right. You're presuming though that I'm guessing it's referring to that guy. So
it's also just a word too, though, isn't it? Like a trump card,
right?
Like,
so,
yeah, but it's not referring to that.
Well, how do you know that? I mean,
well, he could have been cute and said Trump friends card, close friends too small. But he obviously wanted to be more direct political speech. And that's kind of what it is. And the real question is, well, why trademark political speech? Well, he wants to make money on these T-shirts and doesn't want someone to knock off the T-shirts and the logo, right? Which is kind of, insinuating something negative about Trump as well, I think. I mean, this is sort of like the generic statement of what they registered. I mean, what's your reaction? Obviously, Donald Trump doesn't want his name. And then, they said Trump's package is too small on the environment, small on, this is the reverse side of the shirt, small on civil rights, small on immigration rights, small on LGBTQ rights, small on workers' rights, small on voting rights, small on affordable health care for all. I mean, it's not the greatest wording in the world, but it sort of says the political statement. It's not Trump too small, it's Trump's package is too small. And then package is obviously making the sexual innuendo that the hand gesture is making. And I could tell a funny joke here, but I won't, because it'd probably be X-rated. But what's your reaction, Kim, to just the generic trademark regulation that says you got to get someone's consent for their name? That's been around for a long time. That registration, that rule has been around for a long time.
I think it's fair. I don't think it violates First Amendment rights.
Right.
I mean, it's their name. You shouldn't get to use it on something for commercial purposes.
Without their consent.
Yeah, exactly.
Right? Now we get to, we know we're not going to get consent because it's political speech, and ignore the trademark issue and just focus on could Trump stop the political speech? And the answer is no. First Amendment protects political speech. Someone's doing T-shirts in protest. He's a political figure. I guess there's something a bit defamatory about it, but
Yes, but that's exactly it, right? That's exactly why they shouldn't be able to trademark it too, because it's like you're protected against, a case they were going to bring for using their name and likeness or whatever, because it's protected. But then you shouldn't be able to then go get that trademarked.
anyone should be able to do the exact same T-shirt, the exact same logo, the exact same everything, unless you have a copyright infringement claim. They could attempt to copyright the verses and the arrangement and the image, I guess, and put a copyright notice on the T-shirt as well, and claim that they own a copyright, a sort of relatively thin copyright. But to stop the Trump Too Small name, because they probably have a website too. I'm guessing Trump, I didn't go look, but I'm guessing TrumpTooSmall.com must be the place that they have staked out to sell these T-shirts. So this guy goes out and files for registration. I don't know. I'm just going to try to see if Trump Too Small comes up with anything. The registration is refused, and the guy takes an appeal ultimately to the federal circuit and says the refusal was wrongfully denied. The refusal should have been granted. And the federal circuit agrees with him. The federal circuit says, you're right, that this is the First Amendment supersedes that statutory provision. Kind of a surprising ruling, but they took their lead.
I feel like the federal circuit is out to lunch a lot recently.
Well, it's sometimes people think that the federal circuit does stuff that's a little goofy.
I'm just saying they get stuff straight up wrong, especially in patents. But it's like the Supreme Court can't even keep up with the level of idiocy going on there.
Well, it's sometimes designed to say, look, you've taken the law in a certain direction on the First Amendment because you've done stuff to suggest that the First Amendment can be used to force registration. There was a registration for this musical group called Slanted, I think, that the trademark office had denied based on the view that it was a pejorative term to Asians. And the group was like, no, it's our band and we want the registration. And ultimately the Supreme Court agreed and said that whole area of we're not going to register things that seem inappropriate gets treated as that's illegal viewpoint censorship. So the Court of Appeals for the Federal Circuit agreed and said registration has to be allowed. And ultimately, the U.S. had to decide, the Trademark Office had to decide, along with presumably the Office of Solicitor General, do we spend some resources on pursuing this case in the Supreme Court? And they see it important enough to spend probably a fair amount of legal time to brief the petition. I don't know if it's going to be granted, because you could argue, well, maybe the Supreme Court's like, the Federal Circuit's fine. Let's let it go.
Well, now we've got, the issue of the Supreme Court being in this, but yeah.
Well, the question is it worth seeing just how crazy it gets out there? Because you can imagine the slippery slope that we talked about that Jack Daniels argues, that people are going to do all sorts of X-rated stuff to Disney and others. Other famous people can weigh in, right? And say, my name now is going to be taken in vain. My name is going to basically be used in some trademark of another person without my consent. Now, maybe they would say just political figures are at risk for this stuff. But I sent the brief over for a reason, which is I think it's a good example of when the U.S., with the Solicitor General's help, decides to do a brief, they do a really comprehensive job. And it's kind of an interesting brief to study in terms of quality of writing and quality of analysis, because they do have to sort of skirt this question of, well, when is the First Amendment relevant in a conflict with intellectual property law? And when is it not relevant in a conflict with intellectual property law? Because you could argue that this issue is already before the court to some degree.
Well, it's a different here. It's like the actual thing that makes it obvious why they shouldn't be able to get the trademark is because they would be protected against that person coming against them on the basis of First Amendment. So they should be able to trademark something like that. In the other case, I don't know the facts of that case. And that's just a little like they were trying to get denied. They were basically trying to get censored. They were trying to censor them or something, right? Is that what you were saying? With that other case?
The other case is you mean the case involving the slanted.
Yeah.
Yeah, they were essentially saying that the mark is derogatory. Here it's a person's name, right? I'll put up on the screen. Right,
which is it's a little different of an issue.
Yeah, there's actually a statutory provision. I thought it was a trademark office regulation, but it's actually a statutory provision that says Section 1052C, trademark shall be refused registration if, and there's a number of these things, consists of or comprises a name identifying a particular living individual except by his or her written consent. So the question presented is laying out that statute and whether the refusal to register the mark.
So it's straight up a statute. So how in the world did the federal circuit come to a decision that they should be able to trademark that?
Well, I haven't read the Federal Circuit's ruling. It is, I think, attached to the appendix. I don't think they published it. I think the ruling was unpublished, which is kind of, in other words, say here, it's in re Elster, decided August 31, 2022. Court of Appeals opinion is in the appendix. I don't know that, and there's, a TTAB, because you have to go through the TTAB after the final office action. So there's like a whole bunch of proceedings that essentially tell you what happens and what are your rights if a registration is refused, because essentially it starts the machinery of you can do a lot of other stuff. And these cases that are filed,
I would assume from the context that they ruled that it was unconstitutional.
Yeah, they said the First Amendment trumps the statutory.
Oh, they're saying they're calling out the statute, saying that the statute's unconstitutional. Okay.
Yeah, they're saying that in so many words, look, you have to register this because, let's see if the appendix is here. I don't know if there is an appendix here. Maybe there is. Yeah, I think there is. The appendix is here. So everything I sent you has all these materials in it. It's like a little course on trademark law, which is the other benefit of spending a few minutes with it, because in a way you could say, Trump probably should have tried to register some stuff with his name on it. I thought he did. And then they could publish the registration. They could pass it to publication, and then Trump could presumably oppose it as causing confusion. But I don't know if he'd be able to prove that it's going to cause confusion, because it's obviously so political. So here's the Court of Appeal decision. I don't think it was published. So you're asking how did they reason it? And this is from 2018, so it'll tell you how long it takes to get one of these cases all the way through the legal system. And the legal system is it goes from the administrative judge or judges on the Trademark Trial and Appeal Board up to the federal circuit. There's no intermediary like a district court. It's like literally an appeal from an adverse ruling by the Trademark Trial and Appeal Board, right? So you can read all that back and forth. So I think this is what they're doing. They're saying the last 5 years is probably really where the reasoning is right here. The Supreme Court has held unconstitutional 2 provisions of Section 2, Mattal, marks that disparage or bring into contempt, blah, blah, blah. And then this other case, evenly split, blah, blah, blah. But both sides agreed with First Amendment, this Tam case, right? So they are saying the 2 opinions in Tam and the majority opinion in Brunetti each rely on a core postular free speech law. The government may not discriminate against speech based on the ideas or opinions it conveys, and conclude that the viewpoint discrimination doom the 2 provisions. So that's what they're doing. They think they're extending and applying existing Supreme Court.
Right. They do that a lot. They overstep. They want to do something, and then they, kind of take Supreme Court opinions that don't really say something and just say they do.
Or they decide to kind of pinch the Supreme Court into, well, you open this Pandora's box. We're basically going to force you to now deal with what you started, because you brought First Amendment jurisprudence into the trademark office when for many decades, if not centuries, it wasn't recognized. Now, I remember when I was in law school, and the reason I thought this was such an interesting topic, at least for me, is that I remember Mel Nimmer, because he was my first year. I was getting mentorship from him in my first year in law school, and he said the First Amendment is going to play a bigger and bigger role in both copyright, trademark, and he even thought potentially in patent law. I mean, he had a very broad view that First Amendment rights were going to start to raise real havoc in the general area of IP, especially copyright, which was his expertise, but he said trademarks as well. So only 45 plus years later, his prediction is now coming true. And we're finally at that point of his prediction, because this might be the high water mark right here. So this is the Court of Appeal, right? The Court of Appeal, the Federal Circuit, goes through kind of why it thinks registration should be allowed. I guess it's not clear to me that this guy would get registration, because I assume that Trump would oppose the registration. Now, whether that could be stopped or not is another question, because someone would say it's designed to be critical of Donald Trump, right? That's a First Amendment value as well. So can he stop it based on him, based on Trump having his own registration? They presumably might be on T-shirts as well. I guess that's what would be suggested, that Trump better get some registrations going for his T-shirts, right? So he can claim that there'd be some likely confusion, but they'd argue there's no likely confusion here, because it's obviously targeted against him. Certainly the stuff in the back of the T-shirt is, right? The front as well. What's your reaction to that? Could Trump stop this? Do you think Trump could actually stop this registration from issuing based on some likelihood of confusion with his registrations? Anyone want to address that?
I don't know. I would have to, I would think that's too factually charged. There'd have to be facts that establish, like what you're saying, that there would be some confusion with what his products.
Well, it's like saying that Trump.
This is totally, kind of bashing on him. So, would it be reasonable that a person would be confused that this was sanctioned by him when it's very negative?
Right. It's like a replay of the Jack Daniels.
Yeah, I was just about to chime in with that.
No, but the Jack Daniels is weird because it was derogatory of the dog, not Jack Daniels. So that's even that, wasn't weird at all to think that it could be Jack Daniels. I thought there was more confusion there. But Trump is like, he could make the argument that he's one of those trolls that goes out and he like literally will make fun of himself just to get the publicity. So, there's that argument.
He does make fun of himself?
He will literally do anything to be on television. I swear to God. Like, I wouldn't put that past him. So, he could easily make that argument and legitimately make it because I would believe it.
Somewhere in this, Trump is watching, I assume, there must be some IP lawyers that watch this stuff for Trump and are watching the official Gazette to see what marks that have the Trump name in them or come close, even using what Taylor said is the more generic verb, Trump, to trump someone. And they want to see whether it's going to dilute the Trump brand, because the Trump brand obviously on a hotel, maybe it's even a famous mark right now. I don't know. There's a Trump line of ties, business attire. There's a Trump.
Oh yeah, is his hotel still called like the Trump Hotel or whatever?
Yeah, of course.
Trump Tower. That's what.
No, there's a whole lineup of Trump registrations. If you search, if someone quickly maybe went down, you could do it and put it on the screen just to get the flavor. He's got essentially a branding company. So I'm just flipping through the appendix because you can see, there's a lot of writing here by different smart people, right? Including the Trademark Trial and Appeal Board, which typically, goes much more favorably for the trademark office position. And I think that's what they did here. I don't know. Let's see what the ruling actually is. But I think they basically come out in favor of the trademark office decision. Let's see. There's a lot of text here. I'm trying to get to the actual ruling. We affirm the refusal to register the proposed mark under 2C on the ground that it comprises the name of President Donald Trump without his written consent. We do not reach the refusal to register under 2A, false association. Okay, so they went in favor of the trademark office position, as the TTAB typically does. And so, if you look at the history.
Well, they also can't find like a statute unconstitutional, right? So I guess that.
Well, they do. No, they do actually raise it as though they can decide it. They say, there's a section in this ruling where they say, constitutional challenge to 2C, applicant's appeal focuses on assertion, alleges this, alleges that. I think they could theoretically make some decision here. I think they could have decided to do so, but they said that they disagreed. They said that 2C was much more of an objective, straightforward way, independent of any First Amendment issue, regardless of viewpoint, to say an individual's name is protected. Period, full stop. So they did actually decide that it was neutral, which is what the Solicitor General is essentially now re-arguing. Is re-arguing that the Trademark Trial and Appeal Board decision, as well as the examiner's decision, were both right, and the Federal Circuit unanimous decision. So, in general, this is an interesting question of, does the Supreme Court take the case and issue a ruling, or does the Supreme Court hold the case and then maybe send it back to the Federal Circuit in light of whatever they decide in the Jack Daniels case? Because the Jack Daniels case is also under the Lanham Act, and it also raises First Amendment issues. So that's why I think in some ways this is an interesting timing point of view. And in some ways you could argue Jack Daniels should probably be happy that the trademark office, through the Solicitor General, is coming in with this petition. Because in effect, it's like saying the First Amendment stuff has gone way too far, right? Look how far it's going now. It's starting to actually say these statutory provisions, which are content neutral and viewpoint neutral, can also be challenged. And it's like everything can have a First Amendment fight to it. Everything and anything that implicates speech, which is any expression, can have a First Amendment issue wrapped up in it. So I think this is probably happy news for Jack Daniels, that this is something that presumably will be in the background of the pending.
Well, it just seems weird that someone else would be able to protect something that you yourself, that it's about, you're the contents of it. You can't protect it, but someone else can protect it. It doesn't make any sense.
Well, Trump himself could have registered Trump is too big, or Trump is big, or Trump.
But I mean, so someone else gets away with doing something, and he can't do anything about that. But
well, he could.
Then they can go and register that themselves, and then someone else goes and does the same thing, and then that person can go after them, even though Trump can't. That doesn't make any sense.
Well, you're saying if it's going to be First Amendment, it should really be generic and public domain. That's what I think.
Yeah.
You're saying you really are expressing First Amendment values. You're not expressing copyright, and you're not expressing trademark.
Right.
You're saying it's generic in the public domain. You can't register it. No one can. And it's political speech designed to be distributed broadly and widely, including by people who do a knockoff of your T-shirt. And that's different to some degree because it doesn't have any revenue production to it. And it's really not commercial, it's political. Than the Jack Daniels case, where the trade dress is arguably being leveraged to take advantage of the strong trademark rights of Jack Daniels and the bottle design, designed to take commercial advantage, right?
Yeah, it just seems just bizarre to me. Like the conclusion that you're going to come up with if you go down that path, it's just like, what? I don't know what they're thinking.
Well, it would be thinking along the lines of what the Federal Circuit wrote, which is you open the door, and the door is now open for lots of broadside First Amendment attacks, right? And you're sort of using a fair use analysis to say, well, wait a minute, this is commercial activity. It's not, if it's really political, then it shouldn't be subject to any protection. But we also know that political parties will register and try to protect the expression of their slogans, right?
Yeah, but it's there. They're not trying to register something about someone else that person can't stop them from doing because it's somehow political or whatever. And then they can go after someone else for using it, even though the person who it's about can't do that. It's just, that's what I'm saying. Like, that's where it's like, what? It doesn't make any sense.
So did you, Lin-Yan, pull up all the Trump marks using the trademark office stuff? Can you bring it on the screen?
Oh, not all the Trump marks. I found Trump hotels.
No, just, isn't there a list under, if you go to the trademark office site and you just say, I just want to search the word Trump, does it not come up with all the Trump marks?
I will do that right now.
Let's put it on the screen, because I think you're going to see he's got a branding business. So he's got the same arguments that Jack Daniels has. And while she's bringing this up, I think I'm right that there's lots of registrations that, you know, when you do this search, the word Trump, obviously, and probably Trump live, just leave out the dead. Let's just do the ones that are live. We're not interested in dead. And let's see what comes up if you do that query. So,
do you know that he tried to trademark rigged election?
What did he do?
He tried to trademark rigged election.
Rigged election? I mean, there's a bunch of stuff here that probably other people do own. So I wonder how they got that to work out, right? Trump, I'm just looking, USA versus Trump, dump Trump. Like, bring up dump Trump. Is that actually, I mean, that's his name, right? Dump Trump, #2. Can you bring that one up? Can you press the button on dump Trump and see if it's registered? Dump Trump, applicant and individual. It says live. Is it an application or is there registration for caps and so on? So how did this guy get this through? Headwear, caps, T-shirts, and whatnot. This is registered, right? Isn't it? Or is it not registered? It says filing date. Maybe it's not registered.
I don't think it is.
So go down to the next page. What does it say on the next page? Anything? Not registered? It's filing it. Oh, so it's not registered. It was just filed November 2022. Okay, so there's actually a lot of stuff. So go back and let's see if we can find something that's actually registered, because this is not Donald Trump Jr. That must be his, right? Number 13. Press that. That must be registered in for him, right?
No.
Wow. So non-medicated beard conditions. Really? I don't get that. KGT Ventures LLC of Palm Beach, Florida.
Oh, well, it could be him.
Could be him,
He
right?
could be selling his own line of.
Yeah, filing date 22. So I guess we'd have to go back and see something that's older. Is there a button for just go back? And is there a button for just registered? Let's see if we can go to the top. Is there one that's...
Well, you should be able to do it by registration number right there. Whatever has a registration number beside it.
Okay, so go down the page. Keep paging down. Okay, so unity trumps racism. Unity trumps... Oh, trumps. There's the verb. So that's okay. That's...
Yeah. I've seen a lot of that.
Right? Blessings, Trump curses, that's a verb. The estates at Trump National Golf Course, that's him for golf, no doubt. Trump Drive Energy. Wow, I wonder what that is. Trump Drive. Virtue trumps evil. Trump card. Okay, let's look at Trump card, number 35. Trump card. Downloadable mobile application for redeeming loyal. So that's more like the notion of playing cards, right? So
No, that's probably his. It looks like a rewards card for hotels.
Oh, you think it is his? Because it's some company, DTM Operations LLC, Michael Santucci. So you think Michael Santucci is probably his lawyer from 2020? I mean,
I could be wrong, but
technically it's not really using his name. It's using the generic notion of a Trump card, but it's not really the generic card. It's a mobile application. But the point that we're making is
for managing tracking.
Yeah, it might be, you might be right. It might be, but my point is he has lots of little LLCs that bring in royalties from his licensing business. And the licensing business is typically tied to a registered mark of one type or another, like the hotel marks, the golf course marks, presumably the gambling marks. There's a lot of different marks out there. I'm surprised there's only 139. So see if you could find the Trump, what is it? Trump too small. See if you could find that just to see whether they registered. Yeah, there it is.
There it is.
Yeah, so it's not registered yet. So shirts, short sleeve shirts, T-shirts, filed January 2018. This guy, Stephen Elster, located in Concord, California. It's still pending, right? Because it's in litigation, right? So wearable garments and clothing and the shirts. All right, so, conceptually, this is how long this registration is going to take, at least another probably year, if it's allowed, if the Supreme Court allows it. So remember, it goes to publication And then there's an opposition period. Donald Trump, or one of his many other companies, pile on oppositions against this guy and say it's confusing. And so they could decide how they want to challenge what would be a lot of fights for Stephen Elster, who I'm going to guess is probably a lawyer. I bet if we search the California bar, I bet we're going to find out that Stephen Elster is actually a lawyer. You say Stephen Elster, attorney, the California attorney. I'm going to guess. Yeah, there he is right there. Probably a trademark lawyer, right? Oh, employment and labor lawyer. It's probably him, though, right? Is my guess. Also in Concord. I'm going to guess, because isn't that where the registration you're looking for?
Yeah, I don't think you'd find too many Stephen Ulsters in Concord.
Right. I mean, he says Oak Grove Road. That's probably his office, right? If you search, yeah.
Oak Grove Road.
There it is, right? So you got an attorney who's decided to be cute. He's wanted to get a registration. He filed his own registration, I think. I don't know if there's an attorney. I don't know if you can actually.
No.
Right.
I don't know.
But the point is, he's decided to invest in a little bit of a cause celeb to sort of say, I'm engaged in political speech. I'm going to carry this case. I'm guessing he represented himself. I didn't bring up on the screen the trademark office. But who represents him here? We don't know yet, because at the federal circuit, there's probably there's some statement about who represents him, I'm guessing. So the point is, he's probably investing a lot of time, money. I don't think the T-shirt business, that T-shirt, I hadn't heard about it before. I don't know whether it's actually generated any real revenue.
I don't think it's that clever. I've seen much cleverer.
It doesn't look like he's invested a lot of money, right? It doesn't look like, oh, he's really made it into some beautiful piece of art, right? He put together an idea and he decided to run with it. And, probably.
Which is exactly because what you're talking about, you'd be able to protect with, like you were saying, copyright or something. But yeah, the generic, he's not going to be able to protect with that. And that makes this even weirder that they would.
But isn't the issue, though, really not any of this analysis, but whether or not that statute is constitutional given the First Amendment?
Yeah, that's the issue. That's, if they accept certiorari, that's the issue that they would presumably take up. And
yeah, all these other issues have to do with what happens if the mark is granted and if Trump makes objections.
Right. What we're saying is that the gate that now exists is that the trademark office said no, and the federal circuit said yes. You've got to allow it to get to the next gate. The next gate is publication and opposition. And that gate, we don't know what will likely happen in that gate and what new arguments will be made. Presumably, some Trump entities will decide we don't really want our mark to be diluted, because once this guy's in with Trump too small, there's going to be a million other people that are going to come in with some derivation. And the overall slippery slope is that the Trump name becomes out there in a way that has a bunch, your point, that there's going to be a lot of people owning a piece of the Trump brand for their particular political criticism or their particular quasi-political criticism, quasi-commercial activity. So your point, Elizabeth, that it's like what's wrong with his argument is he's trying to own a piece of Donald Trump's goodwill, and that shouldn't be allowed without Trump's consent. Now, maybe if Trump were dead would be different because the statute says if the person is alive. But Elvis, I think the Elvis Presley licensing entity controls Elvis Presley marks and stops people from registering Elvis or Elvis Presley.
Yeah, because you're still protected even if you die for that stuff. But I think it's only it's a narrow area where you can then write about a person without issue. Like, that's when they come out with the movies about people and whatever when they die.
Mm-hmm.
Because they're allowed to have their own take on it, but they can't go using their the marks of that they used in their life or whatever. That's still going to be protected.
Right. So let's say we were being asked to counsel this guy from Concord. I think we would have said to him, you probably should use it like a verb and say, what trumps what? ? And then on the reverse side, you can have all these things that talk about what's wrong with Donald Trump. But the mark would be the verb. The mark would be the 3 words. What trumps what? ? Right? Because then you could avoid the consent. Now, that might still be opposed, but we know that there have been other verb references that have been allowed. But this would be like political speech with trying to get us close to the line of using the Trump name without using the Trump name in a way that brings the protection.
And that's probably why all those different marks sprung up.
Right.
They probably know this. They probably have some thing in mind where they don't want to do that.
Well, there would be a different mark, right? What trumps what with a different logo, and then the reverse side of the T-shirt would presumably tell a different story. It's interesting that the brief didn't include any actual rendition of how the mark is used, because it is just the letter mark. There isn't actually anything that's pretending to be trade dress. But
No, it says word mark.
It's a word mark, right? So just think about this for a second. The reason I bring this up is a good example of these lunch meetings being educational lunch meetings floating into then becoming potential newsletters. Is this fits into the lineup of what we've done with the copyright Warhol Prince copyright First Amendment newsletter, the trade press Jack Daniels First Amendment trademark newsletter or trade dress newsletter, and now this one is essentially the word trademark, not trade dress, First Amendment right to register political speech potential newsletter. Now, why do you do these newsletters? Because if you're aiming to educate people about this area of the law, which is kind of a novel area of the law, but it also brings up all the historical law as well. It enables an interesting little 2-page way to kind of get across that there's some really interesting stuff going on in the field of trademarks and First Amendment that's generating a fair amount of litigation. Now, I doubt that this guy I wonder, I mean, it'd be an interesting interview. I'm going to write to him and see if he wants to do an interview for a podcast. It'd be an interesting question of what did he have in mind? Now, maybe he wouldn't do it because he'd be worried that it would redound to his detriment to talk about how he came up with this T-shirt. But to me, it's a little bit like he decided to put himself out there and to pursue this T-shirt. And he's generated what could be a U.S. Supreme Court issue. He's obviously surprised a lot of people with the Federal Circuit decision, right? So it'd be an interesting question about this T-shirt and where the idea come from. My recommendation would be to say this: what trumps what? He's not going to redo the T-shirt, but I would have done it differently. And then you could probably say on the back, Trump's package is too small. and then environment, civil rights, and all this other stuff, right? It would probably get the message across even better than the way he's done it. But, it's not for me to change the way he decided. There isn't any copyright notice that I'm aware of on this. There isn't even any trademark notice. It doesn't even appear that we put the little TM after Trump too small or after this image. So maybe he didn't get any IP advice at all. But he obviously decided to file a registration. So he must have printed up a bunch of these T-shirts. I wonder how many actually ended up with. So do you think it's a good newsletter topic? I'll just put that question out. Or is it like, nah, it really depends on whether the Supreme Court takes it or not. But I'm going to decide not to take it. What do you think, Jim?
Yeah, I think he should have done the hand. I think that we should wait until the Supreme Court does or doesn't take it, because well, I don't know. It's going to be interesting because.
Well, it's a good example, Lignan, of if you have free time, you doing a summary that can form the basis of the newsletter, and then you could get some byline credit for writing the newsletter, and you can do some editing on it. And you can use the same format that Kim and I have used, where you take this picture from this website. I just did a Google search or Yahoo search on images to bring it up. You could put both sides of the T-shirt, this side of it, as well as the other side of it, because the brief doesn't really do that, but this sort of makes the newsletter more readable if it becomes a newsletter. But it would be an interesting use of a few hours of time to kind of summarize what's at stake here, because effectively the First Amendment decisions that have been made over the last few years are being extended. And the Federal Circuit, at least, was open to extending them. And my point is that when stuff like this comes up, if you want to generate something that just is of some newsworthiness, because it involves a former president, it involves intellectual property rights, it involves an area that he obviously has staked out. You probably could count the number of registrations that he has with the Trump name. I bet it's over 50. I don't know what will bring them up, because I don't think we have all of them in that list. But it's not like he hasn't been active in registering his name in some form for hotels, and probably his daughter as well, for perfumes and lingerie and whatnot, because they have very active.
Got most of hers in China.
Sorry?
He's got most of hers in China.
Yeah, I mean, he's become a little bit of an IP machine to some degree, because his view of life, even though he's in real estate, is a lot of his purported wealth is really from intellectual property. And I think there's some truth to that.
That's correct. I think that is correct.
Yeah, the reason.
I know. I read an article quite a few years ago about that.
Yeah, the reason that to some degree Forbes and others don't really fully understand or appreciate his arguments for why he's one of the top 100 people of wealth is because they don't understand that these.
Well, because he didn't make it himself. He inherited it, and he kind of sucks at making money out of having lots of money. That's why they don't.
But he's built a licensing business without his dad's help. I mean, yes, his dad gave him the first $1 million, but he did build a licensing business that the dad didn't have the foggiest idea of how to do.
Well, I'm just saying why those other guys think that way about him.
Right, but he did build something that generates royalties, probably will generate royalties after his death. He did license the marks. He's got a team of lawyers doing the IP. They've got to be watching this area with some interest and amusement. And I'm kind of surprised. I guess they couldn't really file a lawsuit against the political speech, at least not while he's president, But probably even now it's political speech. And it's your point, Elizabeth, which is, this guy's just engaged in political speech. I mean, it's not something that should be subject to exclusivity. Anyone that wants to do the same thing and say Trump too small should be able to do it without an infringement case, maybe even on a T-shirt, maybe even on a same color T-shirt, maybe even on a T-shirt that has the same list of areas, although probably not identically. Maybe there is some thin.
Right, then you'd get your copyright, which
maybe
that should be enough protection right there for anything you're going to be doing.
Maybe there's a thin copyright. Is kind of the point. So, Lignan, if you have cycles, I think it would be a good writing exercise for you. I'll send you the pictures of the T-shirt. You can use the style.
Okay. Yeah.
Wow. Okay. Thanks very much.
Tune in next time on the Valley Current.